Hello everyone, welcome back to another episode of Coach Today by Live Law, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. The Supreme Court has directed state government and union territories to provide complete information on functioning of open correctional institutions. The bench of Justices B.R. Gawai and K.V. Vishwanathan was dealing with a batch of petitions filed by human rights activist Suhas Chakma, pointing out the issues of congestion or overcrowding of prisons, rehabilitation of prisoners, and legal aid in prisons. To deal with the issue of overcrowding of prisons, the court back in May had suggested establishing open-air prisons or camps. Open-air prisons or open prisons are correctional facilities where inmates have more freedom and fewer restrictions than the traditional ones. They typically lack high walls and heavy security, offering a more relaxed environment. The court was informed that such open-air prison system was effectively working in Rajasthan. The amicus senior advocate K. Parameshwar had back then informed the court of the available data which shows that institutions like open-air prisons were underutilized. So the top court had asked for a questionnaire to be prepared and circulated to obtain information from all the states in respect of status and functioning of open correctional institutions. Pursuant to this, qualitative questionnaire and quantitative OCI chart were prepared for states and union territories to collect requisite information. Now, considering the status of information received as per which many states had not complied with the court's order, it has directed that all the states and union territories which have not yet filed their response must file the same within a period of 4 weeks. In the next update, the Supreme Court has upheld conviction of a husband in a 30-year-old dowry death case as he failed to prove that his wife's death was not related to dowry demands as required under Section 113B of the Indian Evidence Act. This section creates a legal presumption that if a woman dies due to burns or other injury within 7 years of marriage and it is shown that she was harassed for dowry before her death, it is presumed to be a dowry death unless proven otherwise by the accused. The accused may be the husband or her in-laws, etc. The court said that when the prosecution discharged the initial burden of proof that the death of the deceased was subject to harassment and cruelty and had occurred within 7 years from the date of her marriage due to 100% burn injuries, then the onus to rebut the presumption raised against the accused under this section of Evidence Act shifts upon the accused. The court noted that the husband who went to sleep with her in the same room but escaped without any injury when his wife died due to 100% burns was unable to explain as to how the death had occurred. Therefore, his conviction was sustained. The Karnataka High Court has stated that purpose of fair price shops is to ensure that citizens, especially those who are poor and below the poverty line, can easily access essential goods at fair prices. A single judge bench of Justice Suraj Govindaraj dismissed a petition filed by Mahatma Gandhi Ji Gram Hita Mandali, a fair price shop, questioning government's decision to start another shop in the same village. The petitioner here, who owns the already existing fair price shop, claimed that he was not issued notice or heard before the government decided to open a new one. According to him, if the new fair price depot was allowed to open, the number of cardholders attached to his fair price shop would get reduced, thereby affecting his business. Referring to Rule 11 of the Karnataka Essential Commodities Public Distribution Order Control Rules of 2016, he contended that unless a request has been made to the existing authorized fair price shop by the general citizen, no such transfer could be made. The government, on the other hand, contended that on receiving a representation from the villagers only, the order was issued. The number of cardholders attached to the shop of the petitioner were more than 1,200, and as such, a minimum of 500 cardholders will still continue to remain attached to his shop as mandated under the rules. Thus, there would be no adverse impact on the petitioner. The court noted that when the authorization period for running a fair price shop ends, the authorities must issue a new notification to invite applications and issue licenses according to the law. It also stated that the petitioner here has no right to keep all the card holders for his shop. The Rajasthan High Court has held that protection of life and liberty under fundamental rights is more important than validity of a marriage. Therefore, the protection applies even if the marriage is invalid, void, or if there is no marriage at all between the parties. The bench of Justice Arun Monga was hearing a petition seeking protection by a couple wherein the girl was 20 years old and the boy was 19 years of age. They had been living in a live-in relationship for the past few days and intended to get married upon attaining the marriageable age as per law, which is 18 years for girls and 21 years for boys. However, they were being threatened by the girl's parents who wanted her to get married to some other boy. The court directed the police to grant protection to the couple and held that regardless of whether a citizen was a minor or a major, it was a constitutional obligation of the state to treat right to human life on a much higher pedestal. Opinion of the Supreme Court was also highlighted, that is, the right to exercise assertion of choice is inseparable part of liberty and dignity, and once a major chooses his or her life partner, it is not for anyone, be it their family members, to cause hindrance in their peaceful existence. And lastly, the Allahabad High Court has ordered an inquiry against the State Police Department, Office of the Director of Prosecution and Office of Government Advocate over non-disclosure of material facts and evidence in a case which involves a Mahant who has been accused of secretly filming women while they were taking baths. The court expressed concern over the prosecution's failure to present key evidence as sought by the court. It noted that despite its specific orders, in the counter affidavit, the prosecution had failed to annex any evidence. The court stated that in such matters, the police first prepare the instructions, which are then sent through the Office of Director of Prosecution to the Office of Government Advocate. However, the court noted that neither of the three levels took pains to comply with the court's order when filing the counter affidavit, even though there were serious allegations against the applicant for bail in this case, who is the Mahant, and the matter was required to be taken up by the authorities concerned. Thus, the bench of Justice Vikram D. Chauhan directed an inquiry into the matter to be conducted by an officer not below the rank of Principal Secretary. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.